Hi everyone, welcome from Law with Dunk the Law Guy, and today is day 35 of the Case a Day series journey, covering cases across criminal law, tort law, contract law, and the English legal system. If you ever have a case you want me to cover, feel free to pop it in the comments section and I'll get round to it if I can. In today's case of R.V. Nedrick, 1986, the Court of Appeal made it clear that the judgments in the Day 33 and 34 cases of R.V. Maloney, 1985, and R.V. Hancock and Shankland, 1986, needed to be clearer when it came to foresight of consequences and indirect intent. In R.V. Nedrick, 1986, the defendant Nedrick held a grudge against a lady, and so he poured paraffin, which is highly flammable, through her letterbox, and then he went on to light it. Sadly, the lady's son died in the fire, and the defendant was found guilty of murder at trial. On appeal, the Court of Appeal found the defendant guilty of manslaughter instead of murder. Lord Lane, in particular, expressed a concern that a jury may struggle to understand the meaning of intent, and more specifically, indirect intent. He stated that the jury should be directed that they are not entitled to infer, the key word here being infer, the necessary intention unless they feel sure that death or serious bodily harm was a virtual certainty as a result of the defendant's actions, and that the defendant appreciated that such was the case. You can see here the language is changing a little bit regarding what has been used in the past with other tests for foresight of consequences from, say, Hyam and Maloney and Hancock and Shankland. They're now using the terms like virtual certainty in the case of Nedrick. Anyway, carrying on. As a result, the Court of Appeal stated that in order to make the foresight of consequences test easier to understand, which had become confused in Maloney, Hancock and Shankland, and at trial in Nedrick, and to make it easier to apply when it comes to Crown Court trials regarding murder, the Court of Appeal provided two questions for the jury to ask. The first question is the objective part of the Nedrick test. Question 1, was death or serious injury virtually certain to occur? And the second question, which is the subjective part of the Nedrick test, question 2 being, did the defendant appreciate this? Where the jury answer both questions with yes, then the foresight of consequences test is held to be proven, and this is then deemed to be strong evidence for the jury to decide that there is an oblique or indirect intent. And that's it for today. Thank you from Law with Dunk the Law Guy, and I'll see you tomorrow.